opportunity to define in our own terms the country we want to be. This nation is and always has been generous and open-minded towards refugees and has offered a home in times of trouble. From the Huguenots to the Belgians and Jewish refugees, we have a strong tradition of welcoming those who seek shelter. As a child, I can remember my own mother working as a nurse to welcome the Ugandan Asian refugees, and then later the Vietnamese boat people. And this seemed only too natural to me, given that my own father had been evacuated as a child to Canada during the war. This tradition is something which I hope, regardless of one's own views on Brexit or the European Union, we can all agree on. In the period of January 2016 to September 2017, the UK welcomed a total of 9,897 refugees, approximately half of which were female and half were children. We can and we should do more, and we should seek to keep every channel by which people are able to safely seek asylum open and available. The Dublin III regulation is one of the ways in which respect for family life and unaccompanied minors' best interest are kept at the heart of the asylum process. For some 300,000 unaccompanied child refugees, the risks of trafficking and being forced into prostitution or forced labour are extremely high. We know that in the Mediterranean, more than 75% of the 1,600 14 to 16-year-olds arriving in Italy reported being held against their will or forced to work. This staggering statistic is absolutely why we should be working to ensure that there are accessible legal routes like Dublin III, which allow children to apply for asylum safely from the country from which they are in and are not forced to take dangerous journeys to join their family. For children and for adults fleeing conflict, the best place for them to be is with family members. This offers the best possible chance for them to thrive and rebuild their lives post-trauma. The cooperation that the Dublin regulation offers aids this. But as we all know, the Dublin regulations are only a small part of the story, and while the cooperation should remain, it is one strand of a much wider issue. From the Calais operation, just 29 of the 769 children that were transferred to the UK came from the Dublin regulation route. And in 2016, just 355 people were transferred under this route. To date, the UK has taken in 10,538 refugees from Syria, just over half of the number we committed to resettle by 2020. We have so far welcomed around 220 children under Section 67 of the Immigration Act, which my noble friend Lord Dubs fought so hard to obtain, less than 1/10 of the original number committed to. Going forward, is this the sort of country we want to be? Brexit is an opportunity to re-evaluate our priorities as a country and refocus on the country we want to be. An open nation with a generous welcome for those in need of our shelter should be a key part of that. I understand the limitations of Dublin III, but I call on my noble friend the Minister at this committee stage of the bill to clarify and confirm that post-March 2019 the government's new and independent approach to refugees would guarantee that those who benefited from the old system would still benefit under the new, and that no restriction would be put in place preventing those in need from being reunited with their families.
Lord, if I may, I would like to thank the noble lady for that speech. Not just for the speech, because it was the voice of compassionate, socially engaged conservatism which I have always respected. May that tradition in the Conservative Party reassert itself. It's desperately needed at this juncture in our history. My Lords, I thought that what the noble Baroness Dr. Schloss said about the legal situation is a powerful argument which the government must answer. Are we going to strip what have been legal rights away? We do debate in the context of this whole bill from time to time what sort of Britain we want to be. And the noble lady was absolutely right. I share completely her view about the sort of Britain I want us to be. I want us to be a Britain in which the world sees the word compassion in capital letters in all our approach to public affairs. We seem to have lost that, and I want to see it reasserted. But, my lords, I want to thank my noble friend, Lord Dubs, for having brought this. His consistent and tireless work on this issue challenges us all. And it seems to me that if we talk about family and the importance of family in society, this is an issue which we can no longer prevaricate about.
The noble Baroness Stroud was absolutely right to say that respect for family life lies at the heart of this matter. And I think it was that in particular which was the basis for the regulation you look at, the Dublin III regulation, and this particular provision, which is talking about those from outside, unaccompanied adults and children who wish to join a family member who is already here in order to make the application. It is about respect for family life as well as seeking out to give the benefit of the asylum application under the convention to which we are, after all, already parties. So, without elaborating, and with great respect to what has been said by everyone who's spoken so far, I also support the amendment.
My Lords, it's a great shame that there isn't more of a consensus between the two parties or three parties on the whole issue of refugees. We've debated it much over the years, but recently we've got to what I would loosely call an easy peace, and that uneasy peace has been essentially Lord Dubs' Section 67 and Dublin III, and that has produced modest numbers, but very real numbers meeting very real problems. I think Baroness Butler-Slot put her finger on it. The rights that individuals have as a result of Dublin III must be maintained. I hope the noble Lord the Minister will be able to assure us that either they accept these amendments or a very firm commitment to assure us that one way or another the effect of Dublin III will be maintained after Brexit.
Yeah.
May I thank the noble lords who have contributed to this evening's debate, in particular the noble Lord Dubs. I think the word noble is appropriate in so many different ways in the way that we have been discussing this matter this evening. It is a number of years since I worked for the Scottish Refugee Council, and I was struck at that time by a number of the challenges experienced by those who were fleeing and seeking refuge across the globe. At that time, I was very much aware of the challenges which were experienced both in terms of refugees and asylum seekers, and I draw a distinction between the two, as indeed the law does as well. As a member of the European Parliament, those frustrations were also manifest in the manner in which the Dublin regulations were both discussed and indeed ultimately moved toward law, and then frankly not enforced in the manner in which I believe they should have been across the EU. And whilst we look toward Brussels often for leadership in these areas, quite often we are disappointed by what in actual fact happens when we move from the high words which can be found in certain of the discussions toward the realities of deliverance, which can be quite different. I particularly thank the Baroness Stroud, who has again helped us realise some of the realities in which we are facing. And she is right to point out perhaps one of the greater challenges, which is again finding unaccompanied minors themselves in a difficult situation in which they have not, by any means, chosen to be where they are. However, I want to turn specifically to the amendment itself, if I may. And again, I can give assurances, and you'll be pleased to see that sitting in her place alongside me is Baroness Williams tonight, again, who I believe on a number of occasions has affirmed the government's commitment to the ongoing support for those who are seeking asylum and for those who fall within the Refugee Convention itself. However, we must remember that the Dublin regulation is not and has never been a route for family reunification. It is a mechanism to determine the member state responsible for consideration of an asylum claim. Dublin confirms no long-term right to remain in an EU state, whether on the grounds of family relationship or any other basis. If someone is transferred under Dublin to the UK to join an asylum-seeking family member, should that asylum claim fail, they can be removed to their home country. In the UK, around 60% of those who claim asylum are found not to need protection. The Dublin regulation rules are fundamentally different to the family reunion procedures in our own immigration rules, which allow refugees under the Geneva Convention or recipients of humanitarian protection to bring their close family members to the UK, where they are entitled to leave to remain. Furthermore, the Dublin regulation does not create refugee family reunion rights because it deals with asylum seekers, not refugees. Once a person is recognised as a refugee in the EU, they are no longer in the scope of the Dublin system itself, and the family reunification provisions in the regulations do not apply. More broadly, and this is perhaps worth stressing as we consider the movement outside of the EU, the Dublin system has a reciprocal effect in all participating states. The two-way process governs movement of asylum seekers both into and out of the UK. Unilateral rules which place an obligation on only one state don't work. It needs to be reciprocal. Going forward, we do seek a relationship with the EU that will address the entire spectrum, not just of asylum seekers, but refugees and the wider question of illegal migration, not solely on the basis of family reunion. Our relationship with the EU on this matter, above all, will be how we are judged. And I note again the noble Lord Judd noting that particular point. We will be judged on this, and we need to get this right. I would stress, however, the EU also needs to get this right. And if I may be so bold and may be so frank, I don't believe the EU has got this right either. And I believe in the struggles which they are engaging in right now. They are seeking to find that solution, and for as long as we are members, we will be part of that struggle to find that solution. But at the moment, there is no easy way forward, as the EU is finding, as I do not doubt we ourselves will find. As long, however, as we are guided by the noble intentions of individuals such as the noble Lord Dubs, I believe we will be moving in the right direction. And on that basis, my lords, if I may, I would ask you to withdraw the amendment. Thank you.
My lords, I'm very grateful for the first half of what the Minister said. I was slightly less certain about the second half. I wish he'd continued as he started. My lords, the fact is, and I want to consider his speech when we're all wide awake and in a calmer moment, but the fact is that the Dublin III mechanism is still a way in which unaccompanied children have been able to come to this country and join relatives. And that has been a route for them, and over 800 have come by this means, mainly from France, but also from Greece. So whatever the technical argument, it has been a positive right and a positive way to safety for some of these young people. I appreciate what the Minister said about it needing to be reciprocal, and indeed the wording of the amendment is precisely to achieve that. It is talking about that we should negotiate on that basis, which means it has to be reciprocal. Otherwise, I fully understand it isn't going to work, because if the French authorities are not interested, then they will not identify young people in France who might be entitled to come by that particular path. I also agree that the EU has a lot of improvement to go in for. I would like to see, as my noble friend Lord Basson said, an EU-wide policy or Europe-wide policy where we get nearer to common standards on behalf of refugees. It would be more sensible, and I think actually Dublin III is part of that, but it is only a small part of it. So I thank the Minister again for the first half of his speech. I didn't know he'd been involved with the Scottish Refugee Council. Good for him. It didn't last long, did it, the effect? But that's a bit churlish of me. I didn't mean to be so churlish. But no, I appreciate anybody who did work. I used to work for the Refugee Council in London, so I know about the good work the Scottish Refugee Council did. I want to think about it. We'll have to look at the best way of moving this forward at the report stage. I'm grateful to all noble lords who were so supportive for this amendment, and I beg leave to withdraw the amendment.
Is it your Lordship's pleasure that amendments 208A and 208 be withdrawn? Amendments by leave withdrawn. Amendment 209, already debated. 210, already debated. 211, already debated. 212, already debated. 213, not moved. 214, not moved.
I think you're stopping here, aren't you? So, for the avoidance of doubt, 214 will be deemed not to have been called.
Yes. My Lords, I beg to move that the House be now resumed.
That the House be now resumed. As many as that opinion will say content, contrary not content, the contents have it.
My Lords, I beg to move that the House do now adjourn.
That the House do now adjourn.
The proceeding has ended. 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 The proceeding has ended.